Welcome to the Deep Dive. Today, we're jumping into a really interesting Supreme Court case, one that pits state power against federal authority. We're looking specifically at uranium mining. Could a state just ban it, or does the federal government call all the shots there?
That's the heart of it, yeah. You've come to the right place if you want to get the lowdown on this without getting lost in legal jargon.
Exactly. So the big question for the court, does federal law, specifically the Atomic Energy Act, preempt, meaning override a state law that bans uranium mining?
Precisely.
Yeah.
It's all about who gets to regulate what, especially when it comes to nuclear materials.
Okay, so let's start with the bottom line. What did the court decide?
Well, they affirmed the lower court's decision,
Meaning?
meaning the state law banning uranium mining was not preempted. Virginia's ban was allowed to stand.
Okay. State power wins this round, at least on this issue. So the ban is valid.
That's the result, yeah. Now, understanding why requires digging into the arguments from both sides. Let's start with the folks who challenged the state law petitioners.
Right. What was their main angle?
Their core argument was that Virginia's ban wasn't really about mining per se. They claimed it was fundamentally an attempt to regulate radiological safety.
And their point was that radiological safety is strictly federal territory.
Exactly. They argued the Atomic Energy Act gives the federal government, specifically the Nuclear Regulatory Commission, or NRC, exclusive control over nuclear safety issues.
So they saw the state ban as stepping on the NRC's toes?
Pretty much. They also argued that mining uranium ore and then milling it, processing it, are like two sides of the same coin. You can't really separate them.
Okay. And the feds do regulate the milling part.
Oh, absolutely. The NRC has detailed regulations for milling and handling the tailings of the waste material. So the petitioners said, look, if you ban mining, you're effectively stopping milling too, which interferes with the NRC's job.
It's like pulling one thread unravels the whole federal regulatory scheme in their view.
That was the idea. They even suggested, maybe a bit cynically, that Virginia's stated reasons, like environmental concerns about mining itself, weren't the real reasons.
What did they think the real reason was?
They hinted it was really about stopping nuclear power development in the state because of fears about radiation, even if the law didn't explicitly say that, sort of framing it as a mining issue to get around federal authority on nuclear safety.
That's a serious accusation about legislative intent.
It is, and it led to broader concerns. They worried that if this stood, what stopped states from using, say, zoning laws or other local regulations to block federally approved activities.
Like putting up roadblocks using seemingly unrelated rules.
Exactly. It could open the door to states indirectly vetoing federal projects or industries they don't like, even if the direct regulation is federal.
That does sound like it could get complicated.
Right. They also brought up this potential for what Justice Kagan later called gamesmanship. Imagine two states pass identical mining bans, but maybe one state's legislative records talk more about economics and the other talks more about, well, vaguely about safety. Could the court decisions be different based just on that history?
That seems messy, relying on finding the true purpose.
Very messy. It raises questions about consistency and, frankly, how honest states might be about their motivations when drafting laws.
Okay, so that's the case for federal preemption. Strong arguments about federal control over nuclear safety and the practical link between mining and milling. Now, how did Virginia push back? How did they defend their ban?
Virginia's argument was, in a way, much simpler and focused on the timeline. They basically said, hold on, the federal government, under the Atomic Energy Act, doesn't regulate uranium mining at all, not the digging it out of the ground part.
Really? No federal oversight before it's extracted?
According to Virginia, and this was crucial, the NRC's authority only kicks in after the ore has been removed. Once it's mined and ready for milling, then the feds step in.
Okay, so a clear line. Extraction is state, post-extraction is federal.
That was Virginia's position. They argued that banning the mining activity itself falls squarely within the state's traditional powers.
Like what kinds of powers?
Well, regulating land use, for one, protecting natural resources, managing the environmental impacts of mining, the physical disruption, water issues, things like that, separate from the radioactivity later, and also, looking after the local economy.
Which in this area wasn't focused on mining.
Right. They pointed out it was a rural area, heavily reliant on agriculture and tourism, and large-scale uranium mining could disrupt that way of life. These are all classic state concerns.
So they framed it as, this isn't about nuclear safety down the line. This is about the local impacts of digging big holes in the ground right here, right now.
Precisely. They emphasized the potential for massive environmental disturbance from the mining operation itself, distinct from the milling or tailings issues the NRC handles.
And what about radiation concerns during the mining, like dust or radon?
Virginia argued that even if there are some radiological aspects to the mining process itself, Congress simply hadn't chosen to occupy that specific field. The feds hadn't stepped in to regulate that pre-extraction phase.
So a gap in federal regulation that the state could fill.
That was their view. They also mentioned a state group they'd set up to study the whole uranium issue, mining, milling, tailings disposal.
Why was that relevant?
They used it to show their interest wasn't narrowly focused on just stopping nuclear power due to radiation fears, but was a broader look at the entire potential industry and its impacts on the state.
Okay. Now, there's this famous preemption case, specific gas and electric. How did Virginia deal with that? It seems relevant.
Very relevant, and they had an answer. They distinguished their case sharply. PGE, they said, dealt with regulating nuclear power generation, the power plants themselves.
Right.
And the court in PG&E recognized that power generation is an area where both the federal government and the states have regulatory roles. It's a dual system.
Shared authority.
Exactly. But Virginia argued here, with pre-extraction mining, it's different. The federal government hadn't stepped in to regulate, so there was no shared authority framework to preempt the state's action. It was an empty field, federally speaking, before extraction.
That's a pretty critical distinction, isn't it? Shared versus empty field.
Yeah, absolutely crucial to their argument. And finally, they talked about the burden of proof.
Who had to prove what?
Virginia argued that the challengers, the ones wanting to strike down the law, had the burden. They had to show that the state's principal or predominant purpose was an impermissible one regulating nuclear safety.
And if Virginia had other good reasons?
Then Virginia argued, if a plausible non-safety reason existed, like protecting the environment from mining impacts or preserving the local economy, and that reason wasn't directly contradicted by the law's text or history, the law should stand. Courts shouldn't go digging for hidden motives if a valid public purpose is presented.
Basically, give the state the benefit of the doubt unless the purpose is clearly improper.
That's a good way to put it. And, the justices during oral arguments really poked and prodded at all these points.
Yeah, let's get into that. What were some of the key questions or concerns raised from the bench? Justice Gorsuch, for instance.
Justice Gorsuch seemed quite skeptical about the whole idea of courts trying to figure out legislative motivation. He brought up this Shady Grove precedent, which dealt with other complexities of federal versus state rules, and worried about getting into that trouble here with federalism.
Trouble meaning trying to guess why legislators voted a certain way.
Exactly. He asked for examples outside of the 14th Amendment context, where the court really dives deep into state legislative purpose. And he made the point that, well, laws often have mixed motives, right? Lots of reasons behind them. How do you pick the real one?
That's a fair point. What about Justice Ginsburg?
She posed a really telling hypothetical. She asked the lawyer for the petitioners, what if Virginia had just flat out said, we're banning this because uranium mining itself is hazardous, full stop. Nothing about milling or nuclear power safety.
And what did the lawyers say?
He conceded they'd probably lose in that case.
Wow. So the framing by the state was potentially decisive.
It really highlighted that, yeah. Which led Justice Sotomayor to jump in on this purpose issue. She asked, okay, if we do look at purpose, does that mean we start deposing state legislators? How do we handle those mixed motives, Justice Gorsuch mentioned? She wanted a clearer line. When do we look at purpose for preemption and when don't we?
Sounds like she saw practical problems with that approach.
Definitely. Justice Kagan also flagged the potential for states to, hide the ball, the gamesmanship issue, trying to mask an anti-nuclear motive with environmental language.
But she also had a counterpoint, didn't she?
She did. She pointed out that the federal government isn't helpless if a state really tries to sabotage the nuclear industry. The feds have powers like eminent domain. They can condemn land, or they could just mine on federal land within the state.
So there are federal tools available if things get serious.
Right. And she also revisited that PGE distinction, contrasting the dual authority for power plants with the situation here, where federal authority arguably starts later, post-extraction.
Okay, other justices. Kavanaugh.
Justice Kavanaugh focused on the workability. How practical is it for courts to determine legislative purpose? He questioned if just having a plausible non-safety rationale from the state was enough. And he also acknowledged, look, even if the law separates mining and milling in the real world, They're obviously connected.
Bringing in that practical reality, what about Justice Alito?
He had some interesting questions, like could a court actually compare the risks? Is uranium mining objectively more disruptive or dangerous than, say, coal mining, which Virginia does allow? Could that comparison help judge if the state's reason is believable?
That's a tough comparison for a court to make.
It is. He also pushed on whether the NRC really has zero authority over the uranium source material before it leaves the ground, questioning that bright line Virginia drew.
And Justice Breyer, he often looks at purpose, right?
He does. He argued that looking at purpose is, well, normal statutory interpretation. Courts often think about what a reasonable legislator would have intended. He questioned why that tool shouldn't apply here, challenging the idea of ignoring purpose altogether.
So a different take there. Did the Chief Justice chime in?
Chief Justice Roberts asked a practical question. How much uranium are we actually talking about here? Trying to get a sense of the scale of the potential mining operation and the stakes involved.
Okay, so a lot of different angles, a lot of complex issues the justices were wrestling with. Federalism, purpose, practicalities.
Absolutely. It shows just how layered these preemption cases can be.
So pulling it all together, what are the main takeaways from this decision?
Well, first, and this is key, the Atomic Energy Act, as currently written, doesn't explicitly regulate the act of uranium mining before extraction. That lack of direct federal command was huge.
Okay, point one. No federal mining regulation pre-extraction.
Point two. States keep significant power over land use and environmental regulation within their borders. This case reaffirms that traditional state authority.
So states' rights in land use are strong here.
Third, the court showed a definite reluctance to get bogged down in trying to figure out the subjective motives of state legislatures. That's generally seen as a thorny path they prefer to avoid, if possible.
Avoid the mind-reading exercise.
Pretty much. Which leads to the fourth point. If a state provides a plausible reason for a ban that isn't about radiological safety, like environmental protection, land use, local economy, and it fits the law's text and context, that reason is likely to be accepted.
So a credible non-safety reason carries a lot of weight.
It seems so, yes.
Yeah.
And finally, the case just really highlights the ongoing complexity of federalism, right? Dividing power between the feds and the states, especially with activities that touch on national issues like energy and safety, but also have very local impact.
It's a constant balancing act.
It really is.
So wrapping up this deep dive, we've seen the court navigate this tricky intersection of federal preemption and state power. That line between regulating mining itself versus regulating milling and safety afterwards, and Virginia's success in framing the ban around non-safety issues were clearly pivotal.
Absolutely. This case really hammers home how important it is to look at the specific scope of federal laws. Where do they actually reach? And where do they leave room for states to act under their traditional powers?
It also makes you think about how hard it can be to discern legislative intent and that constant tension between national goals and state autonomy.
Definitely. What's the biggest thing that strikes you about this outcome? Does it raise more questions for you about how we manage potentially hazardous materials or activities across state lines? It might be worth digging into the Atomic Energy Act itself or exploring other preemption cases.
Good thought. Well, thank you for joining us on this deep dive. We hope it's shed some light on this significant Supreme Court ruling.
Our pleasure.
And now for our final segment, the 10th chair. We imagine ourselves as that hypothetical 10th justice and offer our own take on the case. Your thoughts from the 10th chair.
Okay, stepping into the 10th chair. I would concur with the court's judgment here. For me, the critical point is the current scope of the Atomic Energy Act. Congress has delegated authority over milling and radiological safety post-extraction to the NRC, but it has not explicitly extended that authority to the physical act of mining itself before the ore is removed.
So the lack of federal action is key.
Yes. In the absence of clear federal occupation of the field of pre-extraction mining regulation, preempting Virginia's law would require, I think, an overly broad reading of federal power and would impinge upon the state's well-established authority over land use and environmental matters within its borders. While the petitioner's concerns about interconnectedness and potential motives are understandable, the legal framework as it stands draws a line. Furthermore, embarking on judicial inquiries into the subjective, possibly mixed motives of a state legislature is fraught with difficulty and risks undermining the separation of powers and principles of federalism. Virginia presented plausible, non-preempted reasons for its ban related to the conventional environmental and economic impacts of mining. Unless Congress acts to specifically regulate this area, or the evidence of an impermissible purpose overwhelming, the state law should stand. This respects the current legislative balance Congress has struck.